Good morning. On behalf of the North Carolina Chamber, welcome to the March 2021 Vaccine Rollout, Workplace and Legal Implications. I'm Kelly Fuller, President of the North Carolina Chamber Foundation. You're all likely here because you're keenly interested in the legal issues surrounding this pandemic-affected world. The law is front and center in many areas where employers find themselves today. Some include congressionally mandated sick leave, continually changing unemployment rules and benefits, navigating workplace safety obligations, and doing what's best for your employees with regard to reducing COVID risks. Whether you can or cannot, should or should not mandate the vaccine. Whether an encouragement for employees to take the vaccine is perceived as coercion, and when you should encourage folks to come back into the office or onto the manufacturing floor again. There are even regulatory efforts at the federal level and litigation pushing for more regulatory efforts at the state level that would change workplace requirements through new OSHA standards. Some of these issues will be addressed today by our presenters. A few housekeeping notes. All attendees are muted to avoid any distractions during today's presentation. If time permits, we will answer as many questions as possible at the end of the presentation. If you would like to submit a question during the meeting, please use the question and answer box. Please do not use the chat box. A recording of today's webinar will be made available to you within 24 hours of the webinar on social media and in the member newsletter. Now I would like to introduce Peter Daniel Jr. to share a legal disclaimer about today's event.
Thank you, Kelly, and good morning. The information provided in this webinar does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. Information on this webinar does not or may not constitute the most up-to-date legal or other information. Audience members should contact their attorney to obtain advice with respect to any particular legal matter. No listener should act or refrain from acting on the basis of information on this webinar without first seeking legal advice from counsel in the relevant jurisdiction. The views expressed today are in their individual capacities only, not those of their respective employers. All liability with respect to actions taken or not taken today, based on the contents of this webinar, are hereby disclaimed. I now have the pleasure to introduce Michael McKnight from Ogeltree Deakins. Michael provides counsel to and represents employers in all types of labor and employment matters. In addition to representing employers in courts and arbitration proceedings, Michael has extensive experience as an advocate for employers in administrative agency proceedings, investigations, and audits before state and federal equal employment opportunity, occupational safety and health, and wage and hour enforcement agencies. He routinely advises employers in investigating and responding to workplace accidents, injuries, and fatalities. Michael regularly works with employers in agriculture, automotive, construction, healthcare, hospitality, manufacturing, retail, technology, transportation, and utilities industries. He also represents and advises nonprofit organizations, schools, and government agencies and officials on matters involving civil rights and campaign finance laws and state and federal constitutional requirements. Michael enjoys working with clients to find innovative, practical, and cost-effective solutions to litigation and workplace issues, and partners with clients to take proactive steps to avoid costly and time-consuming legal problems. Thank you, and Michael, you can turn your video on. Welcome.
Thank you very much, Peter. I appreciate you having me today. It's an honor to be able to present to this fine group. My focus will be on employment law implications of the vaccine. And I think an appropriate place to start is to look at what OSHA has been doing with respect to COVID so far, and what we can expect out of OSHA as there's going to be some developments over the next few days there. So we'll look at the first slide, and I've entitled that slide OSHA versus COVID. And if we could go to that, we'll take a look. There we go. So as many of you know, there are currently no North Carolina or federal OSHA standards on COVID-19. Enforcement by OSHA of COVID issues is based upon the general duty clause that requires employers to provide employment and to employees that is free from recognized hazards that are likely to cause death or serious physical harm. And OSHA has also looked to see whether employers are complying with PPE, respiratory protection standards, and other standards like the record keeping and reporting standards. And despite the vaccine distribution ramping up and a decline in the COVID numbers, federal OSHA is set to release an emergency temporary standard related to COVID-19 by Monday, March 15th. And an emergency temporary standard is not like a permanent standard from OSHA. It's temporary in nature. It lasts only 6 months, and OSHA has to show that there's a grave danger to employees that can be addressed by an emergency temporary standard to bypass the normal rulemaking procedures that usually accompany a permanent OSHA standard. So it will be interesting to see, number one, whether they do roll out with a temporary standard. The consensus is that certainly will happen. That was an instruction from President Biden on one of his first days in office is for OSHA to look at that to see whether an emergency temporary standard was necessary or not, and to come up with that standard by March 15 if it was. So looking at the next slide, we'll take a look at what will the emergency temporary standard look like. Well, there's a general consensus that there are two possible approaches to that. One, and if you have operations in Virginia, you may be familiar with this. Virginia has adopted its own COVID standard. In Virginia, like North Carolina, South Carolina, Tennessee, Kentucky, and a bunch of other states around us are called state OSHA plan states. That means their state government administers OSHA in their states. And in a number of other states around the country, federal OSHA administers the plan. So because Virginia is a state plan state, they adopted their own OSHA COVID standard, which is generally deemed to be a sort of a middle ground approach. It requires employers to conduct a hazard assessment, to make reports when to the local health department when there are COVID outbreaks in the workplace, a certain number within a couple weeks, and to document the way that they're handling COVID issues. So a lot of folks think that would be an easy standard for federal OSHA to adopt if they're going to adopt a temporary standard. But the reality is federal OSHA does not like to adopt state law standards. So what the thinking is that federal OSHA is likely to adopt what's called an infectious diseases standard. And that's a standard that they started working on in 2010, but it was never finished. They got some feedback from a bunch of groups, including groups like this, small business groups, and so on, and they stopped working on it. They essentially put it on the back burner during the Obama administration and never picked it back up. They made it a long-term goal, in other words. But the advantages to this infectious diseases standard from OSHA's perspective, at least, is that it could be applied to future pandemics. But some of the drawbacks are that it really could require a one-size-fits-all approach across all industries. There may not be industry-specific guidance, and it also may be more likely to face legal challenges because it would be a broader standard. It would be something new that employers aren't familiar with. But we'll see what happens over the next few days and what OSHA does on that. So looking at the next slide, what I did is take a look at what are some common themes between, because not only has Virginia adopted its own state OSHA standard, but a number of other states have too. Michigan and Oregon and California have also adopted their own specific COVID standards. And then federal OSHA has put out some guidance about how to handle COVID issues. But there's about 4 common themes that run amongst all of that guidance. One is that employers need to conduct a hazard assessment and adopt a written COVID prevention plan. Second, they need to adopt measures to limit the spread of COVID ranging from physical distancing, barriers, face covering and PPE, improving ventilation in the workplaces, addressing hygiene so that employees can wash hands and have hand decontaminants and things like that, and also to make sure that there's proper cleaning done, both if there is a COVID outbreak or if there's not. And then third, all the guidance put out by the states and federal OSHA so far has focused on keeping potentially infected employees and out of the workplace. And if we think somebody's potentially infected, we want to keep them out. And if someone we know is infected, we want to keep them out, and the people who've been exposed to them. And the fourth element is that no retaliation against employees reporting issues. So I think these four themes are certainly things that we're likely to see in whatever federal OSHA releases over the next few days. And I would imagine that most of you are already doing these things, and that's the good news. It'll just be interesting to see, number one, whether federal OSHA addresses vaccines specifically in that guidance, and what they say about masks and how long those will need to be worn, and so on. So looking at the next slide, North Carolina is kind of in a unique position on this. Some of you may have seen news reports that back in October of last year, the North Carolina Department of Labor denied a request by labor advocacy groups to create a statewide COVID standard. The same groups then turned around and filed a complaint with federal OSHA, which they can do, claiming that the North Carolina Department of Labor has not adequately investigated COVID complaints, and that complaint is still pending. Now, those of you who have had your employees complain about COVID-related issues, or if you unfortunately had a death in the workplace related to COVID, you know that the North Carolina Department of Labor does do an investigation of all of those complaints. Usually you respond to a written letter, and if you end up with a fatality, they either come on site or they conduct a remote investigation that includes employee interviews and lots of exchange of documentation regarding what you're doing to protect employees from COVID. So it'll be interesting to see what federal OSHA does with all that, particularly given the fact that we've got a potential temporary standard coming out. Now, what does that mean for North Carolina? Since North Carolina is a state OSHA plan state, normally it has 6 months to adopt a permanent OSHA standard. If OSHA rolls out with a new standard, the states that are state plan states have 6 months to adopt that. But federal and North Carolina law is not clear on how long they would have to adopt a temporary standard. The interesting thing is a temporary standard is only good for 6 months. So if the state has 6 months to adopt it, my question is, will the state adopt it at all? What will it do? And then the federal government has 6 months to issue a permanent standard based upon the temporary standard. So it'll be interesting to see how all of this shakes out here in North Carolina. But the temporary standard would arguably not be effective right away in North Carolina, at least not until the state decides to adopt it. Now, what does federal OSHA have to say about vaccines? And that's the subject of the next slide. And federal OSHA has put out guidance at the end of January. The new Biden administration put out guidance that updated guidance that had been put out by the Trump administration related to OSHA, and it had two elements in that guidance about the vaccine. One is to make the vaccine available to employees at no cost, but there's no requirement in that guidance to mandate the vaccine. And I think that's important to know. And I think it would be highly unlikely when OSHA comes out with this new guidance over the next few days that they mandate the vaccine across all industries. They may say that it's a requirement for some industries, but I'd be even surprised at that. So we'll have to see what they have to say, but this is their current guidance. They say that rather than mandating the vaccine, employers should provide information and training on the benefits and safety of the vaccinations to encourage employees to voluntarily get them. And they also say that you cannot, as an employer, make distinctions between vaccinated and non-vaccinated workers on protocols. I know the CDC came out with some guidance yesterday that talked about people who have been vaccinated can go visit each other now and do not have to be masked, for example. Well, OSHA is not changing that. They are saying that all workers must follow the same face covering and distancing protocols, regardless of whether they've been vaccinated or not. Again, it'll be interesting to see whether they change their tune on that with the new temporary standard when it comes out. I doubt that will certainly be the case, though. So The next consideration outside of OSHA, I think, is the Americans with Disabilities Act. So a lot of people, we've been getting a lot of questions lately about whether the employers can require employees to receive the vaccination or require proof of the vaccination in order for employees to continue their employment. And the answer to that is yes. And of course, there are always caveats with this, as there are anything else in the law. But it's important to understand that in December of last year, the Equal Employment Opportunity Commission, which is the agency that enforces the Americans with Disabilities Act, came out with some guidance. And this guidance has not been changed by the Biden administration, at least so far. And there's not an indication that it's going to be changed. But that guidance says that the vaccine itself is not considered a medical examination. And those of you who deal with the ADA a lot know that if you give employees a medical examination, there are certain things that you have to do. And namely, it's got to be job related and consistent with business necessity. And that can be a high hurdle. So the good news is a vaccine is not a medical examination. And as a result, you can ask employees for proof of the vaccination to continue their employment, to hire them, and so on. But if a vaccine is required by you as the employer, any screening questions that you ask must be job related and consistent with business necessity if they are asked by you or a contractor of you. So in other words, if you bring someone onto your property to administer the vaccine and you contract with them, then any screening questions they ask are essentially attributed to you, and they've got to be job related and consistent with business necessity. And if you're going to require employees to get the vaccine and to answer those questions or face termination, you've got to be able to show that employees who do not answer those questions or do not receive the vaccination are a direct threat to themselves or others. And there's a 4-part test that you use to determine a direct threat. You look at the duration of the risk, the nature and severity of potential harm that could be incurred, the likelihood that harm will be incurred, and then the imminence of the potential harm. And I think the answer to that, whether an employee is a direct threat will depend upon the employee, the role they play, and the type of organization and the type of employer that you are. So let's look at the next slide, because there are some exceptions to this requirement, and I want to be clear about these. So an employer does not have to meet the direct threat standard, and there's no job relatedness or business necessity requirement if the employer is offering the vaccination to employees on a voluntary basis only. So in other words, if the employee's decision to answer disability related screening questions is completely voluntary and the decision to get the vaccine is completely voluntarily, in other words, there's no coercion or anything like that, then you can ask those screening questions, or your contractor can ask those screening questions. Now, there are some potential liabilities from getting the vaccine. What if someone gets sick from it? What if they have an adverse reaction to it? What if the vaccine batch is bad and all that? My colleague, Nate Huff, is going to be addressing a law, the PrEP Act, that's in place to help provide protections for that kind of thing in the next segment here. But this is, if you're providing vaccines on a voluntary basis, this is one way around the strict ADA requirements on the questions. And if an employee receives an employer required vaccination from a third party that does not have a contract with the employer, you also do not have to meet the job related and consistent with business necessity requirements. So in other words, if you tell employees they have to get the vaccine, but they've got to do it on their own time at a drugstore or in a doctor's office or at one of the various vaccination clinics that are around the state, you are not responsible then for the questions that are asked by the vaccine provider from an ADA perspective. And so it would be my recommendation that if you're going to require vaccines, that you seriously consider having employees get those vaccines from third parties than perhaps bringing someone on your property to give them. But there are also a lot of good reasons why you may want to do that. Other potential pitfalls in terms of vaccines. That's the next slide. One of the main pitfalls that I see when employers work with medical providers is that sometimes there are questionnaires involving family medical history questions. Anytime you ask an employee family medical history questions, that's almost always going to violate a law called the Genetic Information Non-Discrimination Act. So you want to avoid that. And if you are going to require employees to get vaccines, you've got to determine whether if they don't, they're a direct threat. And if you determine employees would be a direct threat to themselves or others, you've got to go through a reasonable accommodation analysis. Are there other things that you could do that would allow the employee to continue working for you, including working remotely, that would not require them to get the vaccine? Can they wear a mask? Can they work in another part of the facility, et cetera? So that's an analysis that you've got to go through. You've got to go through the interactive process. If you're going to require the vaccines and an employee comes to you and says they can't get it either due to a disability or they've got a sincerely held religious belief. Now, another question that we're getting a lot of is, what if I offer incentives? And that may implicate wage and hour concerns, disability concerns, and so on. So you've got to consider whether, if you're going to pay people something extra, number one, that pay is probably going to be taxed. But number two, or people with disabilities going to be disadvantaged if they can't get the vaccine and get the extra pay? How about pregnant people who cannot get or do not think they should get the vaccine? That might implicate Title VII. So you've got to think about all these things when you deal with vaccine incentives. So I've got a few concluding thoughts here for you on the next slide. So in terms of an OSHA perspective, I would consider using the common themes outlined in the previous slide as a baseline for your OSHA practices right now until we get more guidance on the emergency temporary standard. I would encourage employees to get vaccinated, but only require it if there's a direct threat to the safety and health of employees or others if some employees are not vaccinated. I'd also consider, if you're going to do incentives for employees to get vaccines, rather than cash incentives or bonuses or whatnot, consider providing additional paid time off or scheduling flexibility so that employees can get the vaccine. If they have side effects, to recover from it. That seems to be one of the biggest concerns that employees are having right now. I don't know that offering an additional $100 or so gift cards or something is going to push someone over the line to get the vaccine or not. I think scheduling flexibility and paid time off to go get it and to deal with it is probably a better incentive. And then always keep information on employee vaccination status, employee medical information confidential. And so the next slide just lists some resources that you can go through and look at, and that has information that I covered today, including links to our website. And we'll have a webinar when the new emergency temporary standards come out. So with that, I'll turn it back over to Peter and Nate for the next segment.
Thanks so much, Michael, and we appreciate your thoughts there. And as a reminder, please pose your questions in the question and answer box, and we have time for questions at the end, moderated by Kelly Fuller here at the Chamber. Now I have the pleasure to introduce Nate Huff from Phelps Dunbar, a former federal prosecutor with 15 years of litigation experience. Nate concentrates his practice on federal, business, and constitutional litigation and white-collar defense. He has first chaired multiple federal jury trials to verdict. He routinely applies the insight of a prosecutor in leading internal investigations and preventing and responding to government enforcement actions. Additionally, as a member of Phelps Dunbar's agribusiness team, Nate serves as outside general counsel to agribusinesses ranging from startups to large farming operations and agricultural associations. He counsels growers on regulatory compliance, labor disputes, as well as business immigration. Nate is a lieutenant colonel and judge advocate in the U.S. Army Reserve. In that role, the Department of Defense has repeatedly called on him to investigate and prosecute its most high-profile criminal cases. Prior to joining Phelps Dunbar, Nate served as a prosecutor in the U.S. Attorney's Office for the Eastern District of North Carolina. Nate, it's a pleasure to have you today, and the floor is yours. Thank you.
Good morning, and thank you for that kind introduction. Thank you to the Chamber for having us, and to all of you for attending. And of course, thanks to my colleague, Michael McKnight, for those insightful remarks. I'm very excited to talk with you all about an issue that is near and dear to my heart, and that is, how do I keep my clients from getting sued? How do I position them or put them in the position where if they do get sued, they have a good defense and they can find their way out of the lawsuit before the expenditure of a lot of time and money. And one way to do that, if you're talking about COVID, is to make sure that you fully take advantage of the PrEP Act. And so that's what I'm going to talk to you about today, about how to use that act, how to make sure that you maximize the protections that it affords to you and your business. Next slide, please. So here's the roadmap. This is what I'm going to talk to you about. We're going to talk about what the risks are to your business. I suspect you know them, but we'll cover them briefly. We're going to talk about what the PrEP Act is, how it can help you, and what you should do, or the things you should be thinking about to make sure that you can maximize your protection there. And we'll conclude with an example, and I'm going to give you some takeaways and some resources that you can take back with you to your companies, and kind of food for thought and a checklist of sorts to think through your COVID program to make sure that you're positioning yourself well to have a strong defense in the event that you do have to deal with one of these lawsuits. Next slide, please. All right, so what are the risks? They are, as you would expect, the one that I'm focusing the most on, right? Michael's identified several that are very important, right, that are in the employment law realm, right? So you've got to be in compliance with all of the things that he talked about. But I'm talking to you about lawsuits, just straight plaintiffs' lawyers coming after your business, suing your business for things like negligence or medical malpractice or personal injury or wrongful death, those sorts of suits. And so when we're talking about COVID and vaccines, what are some examples? Well, as you all know, or as you may know, vaccines are very safe generally, right? But they're not flawless. I think the statistics on, for example, the polio vaccine, it's, maybe 1 in every 2 million people has a serious adverse reaction, right? And so if you're running a program at your business and you're giving out that vaccine and you happen to hit that 1 in 2 million chance, right, you could get sued, right? So that's an example of a type of risk. We've also seen lawsuits where plaintiffs' lawyers have accused businesses of, failing to give the vaccine quickly enough or not giving it to someone who they say should have gotten it. We've seen lawsuits arising out of, how they gave it, how they administered it. And we've seen lawsuits about failing to prevent COVID, right? So someone, for example, will sue a nursing home and they'll say that the particular nursing home should have done more with PPE or with vaccines. And because they failed to do that or failed to train their staff, someone caught COVID and was seriously sick or died. So there's a whole body of case law that's working its way through the system right now where these plaintiffs' lawyers are finding COVID-related ways to sue businesses. And that's where the PrEP Act comes in, and that's where I want to kind of draw your attention to. Next slide, please. So what's the PrEP Act? Well, what does it stand for? Public Readiness and Emergency Preparedness. So it's a federal law that was passed in 2005, back during H1N1. And the idea was the government wants businesses and individuals to participate actively in countering these pandemics and these public health emergencies. So they don't want businesses to be paralyzed by the fear that if they wade in or if they try to help, they're only going to expose themselves to more lawsuits. So essentially, what the act seeks to do is to take that one concern and lessen it or eliminate it. But it's not in effect all the time, right? So you can see there my third bullet. When is it in effect? Well, the triggering event that kind of invokes these protections is a declaration by the Secretary of HHS. So when there's a declared public health emergency by the Secretary, then the PrEP Act protections become available for people who meet the requirements. So what does it do? It provides immunity for certain types of legal claims. So here's an example of what I'm talking about or how it might work in very general sense, and then we'll get into some details. You decide that you've taken Michael's advice and you've navigated the employment law issues, and you want to administer the vaccine on your campus or in your building to your employees or to everyone in your warehouse. And you want them to essentially line up, and you're going to you're going to bring a company in, and they're one at a time. Everyone's going to get vaccinated, and it's going to be great because your employees will be protected, and it'll protect your operations and the health of your employees. Well, one employee happens to have a serious reaction, and they get seriously sick or disabled, and of course they're going to sue your company, and they're going to have a plaintiff's lawyer that's going to do that, and they're going to seek damages from you for medical bills and for pain and suffering, and all sorts of other compensatory and non-compensatory type damages. And they're going to likely sue you in state court in some county where maybe the jury pool is not pro-business. And what the PrEP Act does, if you've met the requirements, when you come to me or to your lawyer, whoever that is, we're going to be able to take that lawsuit and remove it from state court and put it in federal court where plaintiffs' lawyers don't like to be. And then we're going to be able to get that lawsuit dismissed. And so you're going to have, and that's going to happen early in the proceedings, generally before you've had to do a lot of discovery, before you've incurred large legal bills and all of the inconvenience that comes with litigation. So so that's what's at stake. So if you've done it right and you've met the requirements, that's what you're going to be able to do. But you may be asking yourself, well, what about the employee that was hurt? Are they left out in the cold? And the answer to that is no. The federal government anticipated that issue as well, and so there's a special program that provides compensation for those types of injuries, not from your business, from the federal government. It was part of the CARES Act, so the employee is not left out in the cold either. And if you've done your part, you're protected from that lawsuit. Couple of notes and exceptions. First, notice that in our example, it didn't prevent you from getting sued, right? So the law doesn't block lawsuits from getting filed. The courts are still open, and so people can still file suits. What the law does is it gives you the ability to take that lawsuit to federal court, which is generally a better venue for business, and to then get that lawsuit dismissed. Another couple of important exceptions. One, it doesn't protect you from white collar crime, right? So if you violate a regulation and you have a government agency coming at you for violating a regulation, this act is not going to help you in a lawsuit like that. This act is designed to shield you from the typical types of lawsuits that plaintiffs' lawyers will file for personal injuries and those sorts of things. So a white collar crime or regulatory violation, the PrEP Act is not going to help you. And another big exception that you should be aware of is it's also not going to provide protection for something that you did intentionally, or where you knew that someone was likely to be hurt by what you were doing. So the act doesn't protect, to state it plainly, bad actors. So there are some limits. It's that you want to be aware of when you're putting together your COVID programs and your vaccination programs. Next slide, please. So I talked to you about how it's not in effect all the time. Well, is it right now? Yes. As of March 10th, 2020, the HHS secretary made the declaration that COVID is a public health emergency, and thus the protections of the PrEP Act are available for those who meet the requirements. And in that regard, that second bullet there is kind of a preview for what those requirements are. I've included kind of the legalese so that you can see it. It says, I have determined that liability immunity is afforded to covered persons only for recommended activities involving covered countermeasures and subject to limitations on distribution. So there's kind of 4 things in there that we'll talk about: covered persons, recommended activities, covered countermeasures, and limitations. Next slide, please. All right, so will the PrEP Act protect your business? Again, yes, if you meet the general requirements, and those are them there again. And these are the things that when you are preparing or reviewing your already in place COVID response plans, you want to be looking at these 4 requirements, and you want to be asking yourself, are we meeting these? So that if someone sues you for an issue related to your plan, you can show that you've met these requirements, and thus you can give me or your lawyer the ammunition to get the case against you dismissed. And we'll talk about these one at a time here in the upcoming slides. So next slide, please. All right, so the first requirement is you've got to be a covered person. And there underlined is the statutory definition, right? That's what the law says a covered person is, right? And so some are easy, right? If you're manufacturing the vaccine, then you're a covered person. But some of these terms are a little more broad, and that's where the law gets interesting and for many of you more useful. Qualified persons, that's legal speak for licensed medical professionals. And then the one that I've put in italics there, program planners, is the broadest one. And that's probably the one that's that's applicable to the largest number of this audience. It's a fairly broad term. And what they've done is they've defined it to include anyone who supervises or administers a countermeasure program. Okay. And those terms are broad. And as these cases have been making their way through the courts, and as more suits are filed and more different scenarios are being worked through, that term is being applied, in my opinion, more and more broadly to encompass more and more different types of entities. And so you can see there from my bullets, now the HHS has taken the position that it does include businesses, private sector businesses, includes schools, includes government employees, government contractors, volunteers. And so I think the bottom line there is that your odds of meeting this first requirement are pretty high. Most of you are going to be able to check this box because of the broad way that this term has been interpreted. All right, next slide, please. All right, the second requirement is you've got to be engaged in a recommended activity. And so what is that? Well, that is the manufacture, testing, development, distribution, administration, and use of countermeasures. We'll get into this, but countermeasures, again, are things like PPE, the vaccine, things that are designed to counter the declared public health emergency here, COVID. So if you're involved in the manufacture, testing, development, distribution, or admin of one of these countermeasures, then you can meet the second requirement, which is that you're engaged in a recommended activity. Now, like anything else in the law, it's not always clear right from the face of the language of the statute what all is included. And that's particularly true here with the use of the term administration. And that has been similar to the category of covered persons. That's been interpreted very broadly. And I think the trend that we're seeing from HHS is a desire to capture under the umbrella of administration as many different activities as possible to make the protections of the law as broadly as possible. And so when you're looking at the various activities that you want to engage in as part of your COVID response plan or part of your vaccination plan, you want to have in mind, is this going to qualify as a recommended activity? And one of the themes there that I think that you should pay attention to is, for each activity, you want to be able to articulate how that activity relates to a countermeasure. So, and the way that this works out in practice is, the plaintiff's lawyer is going to sue your business and they're going to list 6 different things that you did wrong. And you're going to want to be able to say for all 6 of those things, well, here's how it connects. Here's how it connects to a covered countermeasure. Here's how it relates to PPE. Here's how it connects to the distribution of the vaccine. And so a couple of kind of examples, or I'll give you the most current current kind of hot button example. So a plaintiff's lawyer will come along and they'll sue a business that has engaged in giving out the vaccine. And what they'll say is, well, you didn't give the vaccine to my client, and my client got sick because you didn't vaccinate them. And of course, they'll file the lawsuit saying that, and then the defense attorney, like me, will say, well, wait a second, PrEP Act, right? PrEP Act applies, you know, your case has to be dismissed. And the plaintiff's lawyer says, oh, no. You know, the PrEP Act covers when you're doing things, right? It covers countermeasure. Here, I'm alleging that you did nothing, right? I'm alleging you failed to do something, and that's not counted. You know, that's not covered. That's not an activity. How can an activity be something that you didn't do? And those are the, you know, that's kind of the case du jour right now, working its way through the courts. And courts have taken competing positions on that issue. And in response to that, in response to some decisions by some courts that have said, yeah, you know, the plaintiff's lawyer is right, the case can go forward, the HHS has issued opinions saying, no, we intend for this to apply even to the failure to give a vaccine. And in those cases, it should also provide protection. And the way that they get there, and I think that they're right about this. What they say is, look, when you're administering, right, and see it's in the first line of this definition on the slide, right? When you're administering a COVID program, part of the administration function is making decisions about who to give the vaccine to and when, right? Decisions about the prioritization of who gets vaccinated and in what order, right? And all of us here in North Carolina are familiar with that prioritization that's happening now, right? Certain groups can get it right now and certain groups can't. And what HHS says about that is, again, that conscious decision-making is part of administering. So what that means for you, for your programs, is your vaccination plans and protocols want to reflect that part of administering the program will be that decision-making. So that you don't leave yourself open to this loophole that, well, you know, this business did nothing and that can't be an activity. You know, so because when you come to me, the way that you arm me as your defense counsel, right, is by not only giving me the facts that I need, but saying, and here's our policy, and it shows who the decision makers are and how the decisions are made, and that we're doing it in accordance with the official guidance from the CDC and state officials, right? So give thought to that. To how your written plans read with regard to that issue, so you don't leave yourself open. But again, this particularly this requirement of recommended activities is every day evolving, because every day the plaintiff's bar is filing new lawsuits with new theories, trying to test the limits, trying to find trying to find a way around the protections of the PrEP Act. And every day, well, not necessarily every day, but frequently the courts are issuing opinions with their interpretation. And then the agency, HHS, is responding by publishing its own guidance, sometimes criticizing the courts. So it's a very dynamic area of the law. And so, you know, in addition to consulting your legal counsel, right, about these issues, you know, another thing that you can do is, at the end, I'm going to give you kind of some links and some resources to where the agency publishes its guidance, and to where the general counsel's office at HHS publishes its advisory opinions. And that's worth looking at periodically, just to see what the latest and greatest is, because it is frequently changing. All right, next slide, please. All right, so covered countermeasures. This is, you know, the third requirement. Again, since today we're talking about vaccination programs, this is going to be a pretty easy bar for you to meet if you're engaged in a vaccination program. But you want to be careful that the vaccine that you're using is one that has been authorized. And, you know, so it's essentially, if you're using, you know, the Pfizer or Moderna or Johnson & Johnson, you're going to have that box checked. But a vaccine, PPE, those things, those are all considered covered countermeasures. The closer calls and the more interesting cases are the lawsuits about social distancing and whether or not. So plaintiff's lawyer sues you and says, look, your COVID response plan didn't call for adequate social distancing, or your plan was good, but your training didn't train your employees sufficiently to account for social distancing. And there you've got employers going to the court saying, hey, this is a covered countermeasure. Social distancing is to counter COVID, right? But the results on that have been mixed, and that's an area of the law that remains somewhat unclear, right? Because countermeasures are typically things like drugs, vaccines, tests, actual equipment, right? Giving an instruction to your employees to stay 6 feet apart doesn't neatly fit into any of those buckets. But at the same time, you've got the agency urging broad application. So you want to look carefully at that issue in your plan. I don't know how that's going to turn out in the courts and which way that exact issue is going to go. Okay, next slide, please. Okay, limitations on distribution. This is your fourth and final requirement. So you're a covered person, you're engaged in a covered countermeasure, and you're doing a recommended activity. But now you've got, what is this fourth requirement? Limitations on distribution. Well, the activity's got to relate to so that first bullet is easy, right? If the federal government is contracted with your business to provide some sort of countermeasure, then that's an easy scenario, right? But it's a little different when it's a private industry that's engaging in these countermeasures. And all of this entire slide basically is lawyer speak for you've got to be acting in accordance with official guidance from public health officials. Okay, so if you're a covered entity doing a recommended activity and it's a covered countermeasure, you got to be doing it in the right way. Okay, and in the right way means in accordance with CDC guidance and state official and the guidance of your state and local officials. There's some case law kind of percolating up through the courts about cases where the CDC guidance was in conflict with the state guidance, and the HHS has issued guidance saying, look, in our opinion, if you're acting in accordance with either and in good faith, the fact that the federal guidance and the state guidance were in conflict doesn't ruin your chances of using PrEP Act. PrEP Act protection is still available to you. So the takeaway for this slide is, again, you want to do it in the right way. And that means in accordance with guidance from official health sources. Okay, next slide. All right, so here's an example. We've talked the four requirements. Let's kind of apply them. So there next to the plus sign is the hypothetical. So the CDC prioritizes certain populations to receive the vaccine because there's only a limited number of doses. A pharmacy applies that prioritization, and because of that, someone seeks the vaccine and is turned away because it's not their turn yet, but then they get sick and they bring a lawsuit and they sue the pharmacy. Okay, so you've got here, this is one of those inaction cases, right? It's you failed to do something. Well, and this example comes from HHS and some of its guidance. So what they say is, all right, the pharmacy is at a minimum a programmed planner, right? And likely even a qualified person, right? Because a pharmacist is a licensed healthcare professional. So you've got a covered person. The decision of who to give the vaccine to and who not to is part of administering the vaccine program. So that checks the box for recommended activity. The vaccine that they're issuing is one of the vaccines that's been approved. So that's a covered countermeasure. And the guidance that's being followed is the CDC guidance. So bang, that's requirement number 4. You've satisfied limits on distribution. So you've got all 4 there. That's a recipe for success. The lawyer in this case is going to be able to remove the case to federal court and get the case dismissed. Next slide, please. So takeaways. The PrEP Act can give you liability protection. It's not going to prevent you from getting sued. It's going to help you win when you get sued. It's got those 4 requirements that we've been talking through, and you want to keep those front and center, and you want to compare your plan, your COVID response plan, your vaccination plans against those 4 requirements, and look at each activity you're going to engage in and who's going to engage in it, and make sure that they all meet all 4. The trend is toward a more broad application. So capturing more covered persons, capturing more activities. But again, this area of the law is evolving very quickly. The plaintiff's bar, as you may know, is very innovative, and there are new lawsuits being filed every day and new opinions coming out frequently. So you want to be checking routinely, regularly with your counsel to see what sort of changes have been made, or if you're sitting down to put pen to paper on a new program, right before you do that, you want to log into these websites that are on my next slide and see what the latest and greatest is. If there's been a new declaration or an amended declaration that's been published, or a new position paper, it's worth the time to take a look at those to see what the latest trends are and requirements are. Next slide, please. All right, so here's the resources. That first one there, that's publichealthemergency.gov. That's an HHS website. So that's where you can see the original declaration by the HHS secretary. And then he's amended that 6 different times. And every time, in my opinion, to make it more broad, to make the protections more broad. And so that's one of the things you want to check before you put pen to paper. You want to read the original and the amendments. There was even an amendment this month. So you want to, February. So that's one thing you want to check. And then the Office of General Counsel at HHS publishes advisory opinions. And those opinions are also very useful because they deal with kind of the latest and greatest and the most controversial areas that are percolating up through the courts. And of course, I would be remiss if I didn't mention my own firm's website and my own article that I wrote about this subject. So I'd encourage you all to check those out. So again, thanks so much for having me, and happy to take any questions that you all might have.
Gosh, thank you, Nate and Michael. I don't know if y'all are like me, my head's sort of swimming. I have a bajillion questions. I've got some great ones in the Q&A box. So let me start with that. Michael and Nate, if y'all want to pop on, these may be to both of you or one of you. Little bit just following up on some stuff that you were just saying, Nate. Could you give some examples of what conscious decision-making might look like that you decide not to vaccinate on site for your employees?
Yeah, so I think the key there is you've got to be able to articulate a deliberative process. And the easiest and best example is the one we've been talking about, right? Where the CDC lays out for you what that process is. There's 4 groups, and you got to go in order, and every person that comes up, you got to deliberate what group are you in, and then make the call whether or not to give it or not give it, right? So that's the kind of the easiest one there. And I think, the other important part about that is, to the extent you're exercising judgment, right? You want the program documents to reflect that, right? To reflect that in accordance with CDC guidance, we're going to be applying this prioritization, or we've only received a limited number of doses, and so we've had to, as part of administering our program, we've had to make choices about who is the highest risk, right? That might be a good example to get you outside of just the standard CDC one. If certain employees are traveling more, or the demands of their job require it, right? You want your documentation to indicate that you are undergoing a deliberative process in accordance with administering your program, and why you thought what you thought, and how it ties to state and local guidance.
Awesome. All right, here's one. Should one get a person that refuses the vaccine to sign a statement that clearly states that it was offered and they refused? either one.
You know,
Yeah.
go ahead,
Michael,
Nate. I think it's,
go ahead. Are you about to throw it to me, or am I going to throw it to you?
no, I'm gonna let you have it.
Okay. Yeah. So, I mean, I like as a trial lawyer, I love to have an exhibit, right? And so it makes it hard for that person to come back and sue you and say, hey, I really wanted this vaccine. It was my turn and you refused me. If they've signed, if you've got a signed statement from them saying, yeah, I don't want to take this right now. So I don't think that you can, and this might bleed over into Michael's area, but I would be hesitant to compel them to sign anything that's going to release or waive legal rights, right? You don't want people asking for legal counsel before they sign it, but certainly something that just says, yeah, I was offered it and I'm declining. I kind of like that.
Yeah, if you're going to have a voluntary program that might be deemed coercive too, I think you've got to be careful how you do it. But I don't think there's necessarily any harm in documenting that someone is declining the vaccine if it's for personal reasons or other reasons, and if it's for reasons related to a sincerely held religious belief or a disability. I think you want to go through the interactive process of trying to see is there a reasonable accommodation that you can make, and that may be one advantage of getting people to sign that is that they're putting pen to paper saying that this is their choice, but you're also making sure that you haven't missed an opportunity to engage in that process with them, which is what the federal laws require on that.
So this is a little bit along those lines. Let's say all of the employees have chosen to be vaccinated except one. Do all the employees continue to have to use protective measures that are appropriate to unvaccinated individuals in order to protect the safety of the one unvaccinated? So in other words, does everybody who's vaccinated have to do all the measures necessary to protect the unvaccinated person, even if they voluntarily refused it?
Well, I think that's a good question, and we'll have to see whether OSHA addresses that in their emergency temporary standard or in other guidance. Currently, the federal OSHA guidance is that you do not back off of things like mask just because some people are vaccinated and some are not. You don't make a distinction in that regard. That's what I meant with that slide, that you would have everyone continue to wear a mask. And I think any guidance we receive from OSHA is going to have people in mask probably for the next 6 months at least, and probably some beyond that. I think that's going to be a safe bet. I think it is a good question though. What do we do about if we have one-off people who decide for whatever reason they don't want it? Either they can't get it due to a disability or a religious reason, or they just decide they don't want it. How long are we going to make everyone wear a mask to protect that person? I think part of it's going to depend upon what we learn about what these vaccines do. Do they prevent non-symptomatic spread? I think I mentioned this, that the CDC has said that people who have been vaccinated can socialize without social distancing and without mask with each other. I think as the guidance evolves, then I think that will dictate part of what we do. I mean, here in North Carolina for right now, I think people who follow CDC guidance in terms of how you exclude people from the workplace and all that, to the extent that might conflict with what the federal OSHA recommendations are, I think you'd be all right to follow the CDC guidance. The federal OSHA recommendations right now are just that, recommendations, are not a standard that you can necessarily be cited under, but in the next few days, we may have a standard if North Carolina chooses to adopt that standard. And if you're in federal jurisdictions, then that standard will be in effect right away, and you could be cited if you didn't follow those.
So can I follow up on that? Because another question had to do with the recently released CDC guidance that just came out. I guess it was yesterday. And CDC, is that yesterday? Monday. It's been a long couple of days. So they said that if you've been vaccinated and it's been within 2 weeks after your second shot, you're good to go with your family and you're good to go with other vaccinated people. So then are you stating that employers should continue to adhere to the OSHA standard versus the state executive order, or the new CDC guidance? In other words, should we require employees to quarantine for 14 days if they're in close contact with someone who's been exposed? I guess based on the new CDC guidelines, what should an employer do in the workplace is really the bottom line.
I think that's a really good question. My understanding of the federal OSHA guidance is there's somewhat of a distinction between the masking and face covering requirements and things like how long you exclude people from the workplace. So my advice would be, I think it's almost a certainty, again, that federal OSHA is going to say that people need to be in face covering and mask for some period of time longer. So I would not treat people who are vaccinated differently from unvaccinated people with respect to face coverings and masks. Now, in terms of how long people are excluded from the workplace, if you've been vaccinated, you don't need to be excluded as long as all that. I think you can follow the CDC guidance on that. I don't think the OSHA guidance, the federal OSHA guidance, speaks specifically to that. And if we get an emergency temporary standard that does, then you would want to follow that as soon as you know that North Carolina is going to be adopting and following that guidance.
All right, so another along those lines, if we mandate the vaccine for our employees, what options do we have for vendors or contractors that work on site?
And that may be more in Nate's department, but I think, from an employment perspective, you can make whatever requirements that you want to make for vendors or contractors. And in fact, if your employees are exposed to potentially getting the virus because of vendors and contractors, you may be required to do something in terms of making sure that they're vaccinated. I do think we will see more and more instances where if you're an employer that sends employees to other places of work, that they will require your employees to be vaccinated to work on specific projects and so on. I think that's very true in the healthcare sector. I've certainly seen that in my own advice giving over the last few weeks. There's been a lot of requests for that. And if you're an employer and you're in a situation where you're sending employees to another work site and your customer requires an employees be vaccinated, you can certainly require that. That would seem to be justified by business necessity. You can't keep that contract if your employees are not vaccinated. You might consider offering your employees other options and seeing if you can allow them to work other places other than that one particular contractor or client if they cannot get vaccinated, particularly due to disability or religious reason. But if you have employees who say, I want to work there, but I'm not going to get vaccinated, I think you certainly have the right to take them off the project if that's what you want to do. So anyway, I hope that maybe that addresses that situation. And Nate may have additional thoughts on that.
Yeah, I think what I would add, and I agree with all of that, and what I would add is, if you contract with someone, for example, to come onto your campus and administer vaccines, the plaintiff's lawyer is going to sue you and them, even if it's their mistake, right? They're essentially going to be acting as an agent of your company, or could be perceived that way. And so you want to paper over in advance, right, that they will comply with state and local guidance and with your own OSHA plan, especially if they're coming to onto your property, onto your campus, your building, right? Because you will be held responsible for their acts. And in that regard, you want to make sure that they're acting in accordance with your plan and in a way that invokes all of the protections of the PrEP Act. So I would caution against the thinking that, well, man, that PrEP Act stuff or that OSHA stuff is complicated. We're just going to outsource this, and then our hands, we don't have to worry about it. I think you still do have to worry about it, and you want to be careful about who you pick, and you want to be careful about how you paper it over.
Wow. Okay, we have a couple questions sort of along this line. if you're not requiring the vaccine, but are encouraging employees to take it, can you require employees who get the vaccine on their own to let you know that they've gotten it? Somebody else asked it a different way, to get a copy. Can you ask them or require them to give you a copy of their COVID vaccine card?
I think you can. I think that's part of that's a good thing about the vaccine itself not being a medical examination. So you can ask, have you gotten the vaccine? Could I have a copy of your vaccine card? Now, I think you've got to ask yourself, why do I need a copy of the card? Is there a specific reason? And I think you also want to ask yourself, is there a specific business reason why I need to know why the people in my organization, and specifically who has been vaccinated and who has not been? I think if you have a good business reason for asking that question, whether it be complying with vendor or client request or whatever, you want to keep that information confidential. You're going to keep it in a file. It's not in the personnel file, and that sort of thing. But I think you certainly can ask that question. What you want to avoid asking is the follow-up question. If the answer is no, you don't want to. If the vaccine is voluntary, you don't want to get into the questions about why, because that invites disability-related inquiries, and that could violate the Americans with Disabilities Act unless it's job-related and consistent with business necessity.
So someone actually asked that question. Is it okay to ask them for a reason why they decided not to get the vaccine, even if it's voluntary? Could you ask them, though, to sign a form that declares that they declined it? They said, I chose not to on my own. Could you ask them to do that instead and not ask why, just ask them to sign the form?
Yeah, I think you could always ask about the fact of vaccination, and you could ask them to affirm that the information is correct, that they did not get the vaccination. You could ask them to essentially put that in writing if you wanted to do that. I guess the question I would have is, why are you going to do that? What is the purpose, and what are you going to do with that information? Because once you ask somebody for something like that, I think it invites questions, at least with the employee, and perhaps suspicion that you're asking for a reason that's not to their benefit or whatever. So I think you want to have a business reason why you need that information and why you want to document it. Nate may know reasons why it's good to specifically document that or whatnot, or some additional language you could put in, things that might somehow affect liability under the PrEP Act. I don't know, but I always caution employers to avoid under the Americans with Disabilities Act. You do not want to ever ask for any more information than what you absolutely need to run your business and to work with employees on accommodations and make sure that they're able to perform the essential duties of their job with or without reasonable accommodation. And when you start asking for more information that you need, that's when you tend to get in trouble with things. But there's always a way to do anything that you need to do. You just got to think through that, I think.
So I had a question more broadly, as both of you all were speaking. I don't know if y'all read the Wall Street Journal this weekend, but there was a very, very large article about OSHA complaints, and that OSHA had not followed up on a lot of complaints that people had made against their employers, et cetera. And they cited, all kinds of stuff. And I guess the question is, does that kind of press lead to more and more plaintiffs' attorneys coming out of the woodwork saying, here is our opportunity? Or do you all foresee some things coming down the pike that employers really need to keep their eyes around what's around the corner? Because at one point, Nate, I was so sort of discouraged. I was like, what's an employer to do, vaccinate or not? It's like a lawsuit is possible either way. You say, we're going to have you on site and we're going to facilitate the vaccination of people, and then you get sued, and then you don't do it, and then you get sued. And so, clearly people need to be seeking their outside counsel and for whatever they decide to do or not to do. They can't just wash their hands like you were saying, but any just big picture things that they really need to be looking around the bend for what potentially is coming down, so that, because as you both have noted, it's always evolving. I mean, this is constant. There's something changing every day. I mean, you got new, a 6-month OSHA rule. What's that going to do? I mean, that's going to make even more complex. So any thoughts you have as we start to wrap it up? Nate, you want to start, and then Michael?
Yeah. So I think the first threshold determination is all of Michael's issues that he's describing, right? And so, because that's the, from an employment law perspective, that's the, can we do this? Is it feasible? Can we even engage in this program at our business, right? And then once you start doing it is where the issues that I was talking about start to come in, right? And it's, if you're going to do it and you can get around the employment law issues, how do you do it in a way where you have protections? And I think that where this is headed, and to answer your question, Kelly, more directly, I think an article like that just increases the interest of the plaintiff's bar in filing more suits. And I think that, these attorneys are sophisticated. And I think that they look at all aspects of it. And so they're looking for an angle to file an employment action, right? But they're also simultaneously looking at ways to structure their lawsuits to get around PrEP Act. And so I think we can expect more and more of these lawsuits. I think we can expect that some unfavorable opinions for the business community about PrEP Act protections. Because I think that, there is a left and right limit to the protections under the Act, and these plaintiffs' lawyers are going to find it. And despite the best efforts of the agency and the defense bar, there's going to be some way to plead these cases where the lawsuits are able to proceed. I think it's limited, but I do expect that they'll find a chink in the armor somewhere.
Yeah, I agree with that. I think the good news with this is that people understand how serious the virus is, how important the vaccinations are. I think courts and I think agencies will give employers latitude if they're encouraging people to get vaccinations and they're actively working with people who can't get it, particularly for reasons of disability, pregnancy, religious reasons, and even perhaps just personal concern about various issues related to the safety of the vaccine. If you're an employer and you're working with people and you're trying to work it out, and I always tell people you want to try to look like you've been more than reasonable with people. And there's always going to be some faction of people who are completely unreasonable, and you're going to have to let them go and exclude them from the workplace because you've got to protect everybody else that you're dealing with on the one hand. And then there's always going to be unreasonable plaintiffs' attorneys who are going to take advantage of a situation like that and use things as an opportunity to sue you. But my advice is to watch the guidance, follow the OSHA guidance as best you can, follow the CDC guidance the best you can. And for the most part, if you're doing that, I think courts and agencies are going to give you the benefit of the doubt. And I think that's the silver lining to all this. And the other silver lining is the vaccine, I think, is going to put this behind us, hopefully by later this year. And attention will be back to other more pressing matters.
Well, gosh, thank you both, Nate and Michael, very much for your comments and your thoughts and your feedback. And thank you all for attending today's vaccine rollout, workplace and legal implications. We hope you found today's content valuable. I know my head is swimming. As you exit today's webinar, you'll see a brief survey, and we would appreciate any feedback you can provide to allow us to improve these sessions. Again, a recording of today's webinar will be made available to you within 24 hours on social media and in the member newsletter. Thank you again for joining with us today. And most importantly, be well and stay safe. For a smile and maybe even a laugh, we have a little short video, and hope you'll join well-known North Carolina faces in masking up for our state. Thank you and have a wonderful, warm Tuesday.
Let's open our restaurants and stores. Wear a mask. Always wash your hands clean. And come on, wear a mask. Let's cheer on our home team. And come on, let's wear a mask. It'll help the COVID stats and get our kids back in class. Let's social distance for you and me, and to help boost our economy. Let's all wear our masks for NC.